Millionaire hid her name from the estate, but one clerk remembered the truth. Clerk remembered. The moment the probate clerk placed a sealed estate envelope on the table in county court, the entire room shifted, because someone had already crossed out a name that was never supposed to be erased, and no one noticed until it was too late. The envelope was old, slightly yellowed at the edges, stamped with a faded estate seal, and inside it was a copy of the original probate file listing that should have included her name from the beginning. But in the version sitting in front of the attorneys that morning, her name was missing like it had never existed at all. No one spoke at first. Not the lawyers. Not the family. Not even the judge who had already begun reviewing the distribution schedule. Silence in courtrooms is never empty, it's controlled. And today, that silence was covering something expensive. Something signed. Something removed. The younger white American woman stood near the back of the room in a simple blouse and plain shoes, the kind of presence people overlook before they even realize they've done it. She wasn't loud. She wasn't demanding attention. But in her hands was something that didn't belong to emotion, it belonged to structure, copies of bank records, old email threads, and a printed ledger showing consistent financial activity tied to the estate accounts over several years. She wasn't guessing. She wasn't arguing. She was documenting. Across the aisle, the white billionaire mentor sat quietly, dressed in an understated dark suit that didn't signal wealth so much as understanding. He didn't interrupt. He didn't intervene. He just watched the way systems reveal themselves when pressure is applied correctly. The case on paper looked simple to everyone else in the room. A large estate. A structured inheritance plan. A distribution schedule already approved by legal counsel. But underneath that structure was a question no one had fully asked yet: whose name controlled the original filings, and who had the authority to change them later? The attorney spoke in careful language: trust documents, probate sequencing, filing history, but none of them addressed the gap between the first submitted estate record and the version now being enforced. That gap was where everything dangerous lived. The woman had worked quietly around that gap for years without realizing she would one day need to prove it. She wasn't part of the loud decisions. She wasn't in the meetings where signatures were debated. But she had something more permanent than participation: she had records. Old emails showing instructions. A time-stamped bank ledger showing contributions made under her oversight. A contract clause buried in early estate planning documents that referenced her role indirectly, not by title, but by function. The kind of language people ignore until it becomes the only thing that matters. What most people in the room still believed was simple: she was not listed, therefore she did not belong. But that assumption only works when no one checks the history of the file. And someone had checked. Or more accurately, someone had remembered. The clerk at the side desk, an older man with decades of administrative work behind him, kept glancing at the sealed envelope as if it was heavier than paper should be. He had seen earlier versions of this estate file pass through his hands years ago. He remembered names that no longer appeared. He remembered corrections that were never supposed to be reversible. And he remembered one specific detail that no one else seemed to notice anymore: the original filing had been amended without a clear recorded justification in the ledger. The billionaire mentor finally leaned forward slightly, eyes fixed on the envelope, as if reading it without touching it. In his experience, wealth rarely disappears in dramatic moments. It disappears in edits. In missing signatures. In documents that quietly change ownership before anyone realizes the story has shifted. And in that courtroom, as the sealed estate file sat waiting to be opened fully, one truth had already begun forming beneath the surface of everything being said out loud: in matters of inheritance, power is not what people claim in the room, it is what survives in the paper when the room gets quiet enough to check. The county courthouse in the morning looked like every other government building in America: fluorescent lights, slow-moving lines, the sound of paper being shuffled like truth itself depended on organization. But inside courtroom 3B, nothing about the atmosphere felt ordinary anymore. The probate clerk's sealed envelope from Part 1 had already been entered into the record queue, and now the case had shifted from routine estate distribution into something far more fragile: document verification. Outside the courtroom, life had continued exactly as it always does in the United States: mortgage statements due at the end of the month, insurance bills sitting unopened on kitchen counters, grocery receipts folded into wallets, and credit card balances quietly growing in the background of suburban routines. The same kind of life the younger white American woman had lived for years. Nothing flashy. Nothing loud. Just responsibility measured in paper, timestamps, and quiet accountability. She didn't look like someone who would be central to a multi-million-dollar estate discussion. That was the first mistake people always made about her. She wore simple clothing, carried a modest folder, and spoke only when necessary. But inside that folder was something more structured than confidence. It was proof. Bank records showing consistent transfers tied to estate-related accounts. Old email threads confirming instructions she had executed without recognition. A spreadsheet she had maintained for years without ever being listed as its author in public filings. What most people in the room still mistook for weakness was actually discipline. She had learned early that ownership in America is rarely about who speaks the loudest in a room, it is about whose name survives when systems are audited. That lesson had come not from wealth, but from watching how wealth behaves when challenged by paperwork. Across the room, the white billionaire mentor remained seated, observing without interruption. He didn't look like someone trying to control the situation. He looked like someone studying it. His presence in the courthouse was understated, almost invisible to those focused only on hierarchy. But he understood something. Most people in the room were only beginning to suspect estates don't collapse in arguments. They collapse in inconsistencies. Earlier that morning, the family had spoken confidently. Attorneys had referenced finalized distributions, approved trust structures, and legally binding schedules. The assumption was clear: the version of the estate file currently being used was the correct one. The missing name from the younger woman was treated as settled fact. Not questioned. Not revisited. Just accepted. But acceptance is not the same as accuracy. The clerk's earlier hesitation had already changed the energy in the building. He had gone back through archived notes, comparing timestamps in the probate system against the physical ledger entries stored in administrative records. And what he found did not match the confidence of the room. There had been an amendment. Not just a clerical update, but a structural revision to the estate file that had removed a listed participant without a clear procedural explanation attached to the record history. That kind of absence is not supposed to happen in clean legal systems. In the small gap between original filing and current version, the entire conflict lived. The woman understood that better than anyone else in the room. Not because she was emotional about it, but because she had lived inside that gap for years. She had seen documents approved and later reinterpreted. She had seen responsibilities assigned without titles, then erased when recognition mattered. So she kept everything. Every email. Every instruction. Every confirmation that could be traced back to a decision point. That is why she was not surprised when people underestimated her. They were not looking at her work, they were looking at her appearance. And in financial and legal systems, those two things almost never match. The billionaire mentor finally spoke quietly to no one in particular, his eyes still on the clerk's table where the sealed envelope sat partially opened for review. In systems like this, he said calmly, the truth doesn't disappear. It just gets filed incorrectly until someone checks the history. The woman didn't respond. She didn't need to. She already knew the next step wasn't confrontation, it was confirmation. The clerk's ledger. The archived probate entries. The original estate submission record. Somewhere inside those layers was the version of reality that had been replaced without explanation. And as the courtroom waited for the next document to be read into record, one thing became unavoidable: the most important proof in the case was not what had been presented in front of everyone, it was what had been quietly removed from the file history, waiting for the moment someone finally decided to look backwards instead of forward. One of the most dangerous illusions in American wealth stories is how quickly people confuse appearance with ownership. In the county courthouse, under fluorescent lights and procedural silence, that illusion was breaking apart piece by piece. What looked like a simple inheritance dispute was actually a collision between perception and documentation, between who looked like they belonged in the estate, and who could actually prove it. The younger white American woman stood in the same position she had been in since Part 1, not at the center of attention, but at the center of the evidence. And yet, the way people looked at her still hadn't changed. To them, she still looked like someone outside the system, modest clothing, quiet posture, no visible signals of status. That was the first false belief in the room, that people who don't perform wealth must not understand it. The second false belief was even more expensive. People assumed silence meant weakness. But silence in her case was not absence, it was storage. Storage of records, emails, confirmations, and financial trails that did not need emotional reinforcement because they already existed in written form. In her folder were transaction histories, internal correspondence, and archived instructions that tied her work directly to estate-related activity. Not speculation. Not interpretation. Documentation. Across the aisle, family members and legal representatives continued to operate under another assumption, that proximity to the deceased automatically translated into authority over the estate. That being related meant being entitled. But probate law in the United States does not function on proximity, it functions on designation. Names in filings. Valid signatures. Recorded intent. Verified updates. And that gap between assumption and law was widening. The white billionaire mentor remained quiet, observing the structural breakdown with the patience of someone who had seen systems fail not because of corruption alone, but because of interpretation errors repeated long enough to become accepted truth. He didn't intervene. He didn't correct anyone. He simply watched how quickly confidence collapses when it is not supported by paper. Around them, the broader set of false beliefs became more visible. People confuse looking rich with owning assets. They assume expensive presentation equals financial control, when in reality ownership is defined by titles, deeds, and account structure, not lifestyle signals. People confuse being loud with being prepared. In the courtroom, volume meant nothing. Preparedness meant archived records that could survive review under pressure. People confuse monthly payments with ownership. A mortgage statement can show responsibility, but not necessarily control. Ownership is recorded in deed history, not in payment frequency. People confuse family pressure with legal proof. Emotional authority may dominate a room socially, but it does not override probate filings, trust documents, or estate schedules. People confuse public shame with private records. What feels like social positioning in the moment becomes irrelevant when bank records, email chains, and ledger entries are entered into court evidence. People confuse boardroom confidence with actual competence. Confidence can be performed. Documentation cannot. And somewhere in that room, a question began forming, not spoken aloud, but unavoidable in its implication: how many people in this system are trusted because they look correct, instead of because they are documented correctly? The younger woman had already answered that question in practice, even if no one had acknowledged it yet. Her approach had never been about confrontation. It had been about preservation. She preserved emails when others ignored them. She preserved records when others assumed they were unnecessary. She preserved financial trails when others believed trust would be enough. That distinction was about to matter more than anyone in the room expected. Because behind all the assumptions, behind all the family claims and procedural confidence, there was still an unresolved legal layer in motion, one that had not yet been fully examined. The probate file that had been introduced earlier. The archived ledger referenced by the clerk. The original estate submission that did not match the current version being enforced. And in legal systems built on documentation, inconsistencies are never neutral. They are signals. The question was no longer whether something had been removed. The question was who could prove it, and what the official record would look like once the system was forced to reconcile its own history. In American estate and financial disputes, the truth rarely depends on emotion. It depends on structure. And structure always comes down to one thing: documentation. That is what no one in the courthouse fully wanted to say out loud yet, but it was already shaping everything happening inside probate court. A will only controls distribution when it is legally valid, properly executed, and correctly filed within the estate record. If it is missing signatures, improperly updated, or inconsistently amended in the probate file, it loses authority regardless of intent. That is why the sealed estate envelope introduced earlier mattered so much. It wasn't just paper. It was the reference point for validity. A deed shows ownership, not assumption. In suburban America, people often confuse living in a home with owning it, but legally, ownership is determined by recorded title history. If a name is not on the deed, it does not matter how long someone lived there or contributed to expenses. That distinction becomes critical when estates include property transfers tied to inheritance claims. Mortgage payments do not automatically equal ownership either. A person can carry the financial burden of a property for years, making payments, covering insurance, managing taxes, without ever being listed as the legal owner. In court, the difference is not emotional, it is structural. That is why reading mortgage history alongside deed records becomes essential in estate verification. Bank records then fill in the gaps that documents alone don't explain. They show who actually carried financial responsibility, who funded what, and who sustained obligations when others were absent. In disputes like this, bank records often become the quiet backbone of truth because they do not rely on interpretation. They rely on transaction history. Contracts function the same way. A contract is not just paper, it is power distributed through language. A single clause in fine print can define control, ownership rights, or exclusion. That is why the younger white American woman's archived documents mattered more than anyone initially realized. She wasn't relying on memory. She was relying on clauses, timestamps, and recorded instructions. An old email can also carry legal weight when it proves authorship or intent. In modern estate and business environments, email chains often serve as informal but critical evidence of decision-making. A single message confirming direction, responsibility, or approval can reshape how a court interprets actions taken years earlier. Even a business plan has an origin point. In disputes involving inheritance or asset transfer, establishing who created foundational documents matters because origin determines authority. If someone contributed structure, design, or execution early on, that history can influence legal interpretation of ownership and participation. A boardroom title, however, does not erase receipts. Titles are organizational labels, not proof of contribution. Payroll records, expense reports, and bank transfers often tell a more accurate story than executive positioning ever could. That is why payroll documentation often becomes one of the most revealing elements in financial disputes. It shows priorities in real numbers, not spoken narratives. And fine print, often ignored, can either protect ownership or quietly dismantle it. Many disputes in probate and business law are decided not in dramatic moments, but in overlooked clauses that define rights, exclusions, or amendments. This is why the next procedural step in the courthouse mattered so much. The probate clerk was now preparing to re-examine the estate file line by line, comparing the current submitted version against archived ledger entries and earlier filings. The sealed envelope from Part 1 was no longer just symbolic, it was becoming a reference point for discrepancy analysis. The younger woman finally stepped forward with her folder, not to argue, but to submit one simple request into the record, a formal comparison between the current estate file and the original submission history. No emotion. No accusation. Just procedure. Across the room, the billionaire mentor watched quietly, knowing that the system was now doing what it was designed to do. When pressure meets documentation, it begins to correct itself through verification, not debate. And as the clerk turned back toward the archived estate ledger, hands slightly slower now, recognizing what might be about to surface, one final question lingered unspoken in the room. What happens when the official file and the historical record no longer agree, and someone finally opens the version that was never meant to be reviewed again? By the time the probate clerk returned with the archived box, the atmosphere inside the courthouse had already changed from routine procedure to controlled tension. Nothing had been officially overturned yet, but something quieter had begun to happen. Attention had shifted from the people in the room to the paper on the table. The clerk placed a second folder next to the sealed estate envelope from earlier. This one looked older, less formal, marked with internal probate indexing numbers that didn't match the current version being used in court. Inside it was the kind of material most people assume never gets revisited once an estate is finalized. A forgotten will draft. Not the polished, final version being enforced today, but an earlier submission, time-stamped and filed during the estate's initial probate phase. The paper itself was unremarkable at first glance, standard legal formatting, dense paragraphs, signature lines. But what made the room quiet wasn't the paper, it was what was missing from the current version and present in this one. A name. The younger white American woman didn't react dramatically when she saw it. She simply stepped closer, as if confirming something she had already suspected rather than discovering something new. Her posture stayed steady, her expression controlled. That difference mattered. She wasn't reading for emotion. She was reading for continuity, comparing what existed here with what had been removed elsewhere. Across the room, the billionaire mentor leaned slightly forward, eyes narrowing just enough to indicate recognition. He understood what most people were still resisting. This wasn't about a single document. It was about version control inside a legal system that depends entirely on traceability. Then the clerk opened a second item. A sealed letter. The envelope was thin, worn at the edges, with an old signature scrawled across the back flap, predating the current estate filing. It wasn't dramatic. It didn't need to be. What it represented was authorization intent before administrative revision. In estate law, that distinction can decide everything. The room still didn't fully react, because most of the people there were not yet processing the difference between what is filed now and what was originally recorded. But the woman was. She had already seen this pattern before in smaller contexts, business records, internal approvals, financial summaries that changed shape after leadership shifts. That is why she had never relied on verbal recognition or social acknowledgement. She relied on paper continuity, the chain of documents that prove who was involved before narratives were rewritten. The clerk then brought out the third item, the old ledger. This was not part of the official court packet. It was an administrative record, maintained quietly over years, tracking estate file changes, amendment logs, and internal notes that never made it into public filings. It showed timestamps. It showed modifications. And most importantly, it showed something subtle but critical, an entry indicating that the estate file had been revised after initial submission without a clearly documented justification attached to the change history. That detail didn't accuse anyone directly. But it didn't need to. In legal environments, unexplained revision history is often more powerful than direct testimony. The younger woman placed her documents beside it, bank records, email chains, and a printed summary of financial activity tied to estate-linked accounts. She didn't elevate her voice. She didn't challenge anyone in the room. She simply aligned her records with the clerk's ledger, point by point, as if building a bridge between two versions of the same reality. And for the first time, several people in the room stopped talking. The billionaire mentor noticed something else, something more subtle than the documents themselves. The shift in perception from the opposing side had not come from persuasion. It had come from exposure. They were not being convinced. They were being confronted with alignment between independent records. Yet even as the evidence began to quietly stack against the assumption that had dominated the room earlier, the opposing family members and legal representatives still held onto a different belief, that presence, title, and familiarity would ultimately outweigh technical discrepancies. That belief is common in high-pressure estate disputes. People assume authority belongs to whoever looks most socially positioned. But here, that assumption was starting to weaken. The woman didn't speak until she needed to. When she finally did, it wasn't to argue, it was to request procedural confirmation that the archived ledger and the current probate file be formally compared for consistency before any further distribution decisions were executed. It was a simple request. But it changed the direction of the room. Because once comparison begins, outcomes stop being negotiable. And as the clerk prepared to reconcile the two records side by side, one truth became unavoidable in the silence that followed. Everything in the case now depended on which version of the estate file would survive contact with the full historical record, and who, exactly, had been missing from the official story all along. As soon as the comparison between the archived ledger and the current probate file was formally requested, the tone inside the courtroom shifted in a way no one could ignore. It was no longer just about inheritance distribution. It had become about credibility of records. And in American estate law, once credibility becomes the subject, everything else becomes secondary until it is resolved. But pressure always arrives faster than resolution. The first wave came from the family members and heirs seated closest to the estate council table. Their arguments were not technical at first, they were emotional, strategic, and familiar. They questioned timing. They questioned intent. They questioned why the younger white American woman had appeared only now if she truly had relevance to the estate. The implication was not spoken directly, but it was clear, if she had been important, she would have been visible earlier. One attorney leaned forward and framed it in a more legal tone, but the message was the same. He suggested that her involvement looked retroactive, implying opportunistic behavior rather than legitimate standing. Another family representative added something sharper, calling her a late claimant trying to attach herself to a finished estate. She did not respond immediately. Not because she lacked an answer, but because she understood something most people in that room were still resisting. Pressure is not evidence, but it is often used to replace it. The white billionaire mentor remained silent, observing how quickly narrative pressure attempts to override documentation review. He had seen this pattern before in estate disputes and corporate transfers. When clarity begins to surface, the first reaction is almost always social resistance before legal acceptance. The woman finally spoke, but her tone stayed even, controlled, and procedural. "I am not asking for recognition based on timing," she said. "I am requesting reconciliation of records based on filing history." That distinction mattered. She was not positioning herself emotionally. She was anchoring herself in process. But the pressure did not ease. Instead, it intensified. A relative of the estate made a more direct attempt to redefine her position. Entirely. The argument shifted toward character, suggesting instability, suggesting misunderstanding, suggesting that her interpretation of the records was incomplete. Another lawyer implied she was misreading administrative history without understanding estate context. This is where most people fold in financial and legal disputes, not because they are wrong, but because they are overwhelmed into accepting social consensus over document integrity. And that is exactly what makes pressure so effective. Because pressure does not need to prove anything. It only needs to make people uncomfortable enough to stop asking questions. But the younger woman did not stop. She simply placed one additional document on the table, a consolidated comparison sheet she had prepared earlier. It aligned timestamps from the probate file, entries from the clerk's ledger, and archived email confirmations tied to estate instructions. No interpretation. Just alignment. The room did not fully react yet, but the tension shifted again, subtly. Because now the disagreement was no longer theoretical. It was structural. The clerk, still standing near the record station, quietly confirmed that the requested side-by-side verification between the archived ledger and current probate file was in progress. That confirmation alone introduced a new reality into the room. Nothing could proceed to final distribution until reconciliation was complete. That is the moment pressure changes direction. When people realize speed is no longer in their control. The heirs, sensing delay, tried to push for settlement framing, suggesting that even if discrepancies existed, it would be better for everyone to resolve matters quickly. That language is common in estate disputes. It sounds practical. It sounds reasonable. But in practice, it often serves one purpose: to finalize decisions before full review is completed. The woman recognized that immediately. Because she had seen that pattern before in smaller financial contexts: contracts signed under urgency, agreements finalized before full clause review, decisions made to avoid conflict that later cost ownership clarity. Pressure creates shortcuts. Shortcuts create loss of control. And loss of control is often irreversible once signatures are finalized. The billionaire mentor finally spoke, not to intervene, but to clarify something simple enough for the room to understand. People don't make bad decisions because they lack information, he said calmly. They make them because pressure convinces them to stop verifying it. That statement did not target anyone directly, but it landed everywhere. And for the first time, even the opposing side began to hesitate, not because they were convinced, but because they realized something important. If the records were correct, rushing would be dangerous. And if the records were incorrect, rushing would be irreversible. The clerk's voice then cut through the tension, announcing that preliminary cross-referencing had revealed inconsistencies significant enough to require formal pause in any final estate execution steps. No celebration followed. No confrontation erupted. Only silence. Because in legal and financial systems, the moment execution is paused for verification is the moment everything becomes uncertain again. And as all eyes shifted toward the clerk preparing the final reconciliation report, one question quietly rose to the surface of the room, unspoken, but unavoidable. If pressure is what made them confident before, what will it do now that it no longer controls the timeline? The courthouse went completely silent the moment the clerk returned with both files laid side by side, the current probate estate file and the archived ledger pulled from administrative storage. No one spoke at first because everyone in the room understood, even before anything was read aloud, that what happens next in a probate comparison is not opinion, it is reconciliation. The clerk began carefully, almost cautiously, as he walked through the first section, named beneficiaries in the original will draft. His finger traced the archived document slowly, confirming line by line what had been recorded years earlier. And then the first contradiction appeared, not dramatic, not emotional, just factual. A name that existed in the archived version was missing in the current probate file. The younger white American woman didn't react outwardly. She simply exhaled slightly, as if confirming something she had already prepared for rather than discovering it. Across from her, several family members shifted in their seats, expecting explanation. But explanation was not the next step. Verification was. The clerk moved to the second comparison, financial responsibility records. Bank documentation tied to estate-related accounts showed consistent payments made toward maintenance costs, tax obligations, and insurance coverage during a critical period of the estate's transition phase. Those payments were cross-referenced with archived notes in the ledger. The pattern was clear. One party had carried financial obligations that were not reflected in the current estate recognition structure. Still no one spoke. Then came the third layer, property documentation. The deed history was pulled forward. It showed a recorded interest associated with early estate structuring that had been referenced in the original filing but not carried into the final distribution version currently being enforced. The clerk did not interpret it. He simply read it. And in probate court, reading is often more powerful than arguing. The billionaire mentor leaned slightly back in his chair, eyes steady. He had seen this moment before in different forms, corporate restructures, estate disputes, asset transfers, but the pattern was always the same. When documents align against assumptions, silence becomes the only reasonable response. The clerk continued. He moved to internal estate records that included responsibility logs, who maintained administrative oversight, who approved drafts of financial summaries, and who contributed to early structuring documents like spreadsheets and planning drafts. The archived file showed consistent involvement from the younger woman's documented contributions in ways that had not been reflected in the final estate presentation. Not emotional involvement. Documented involvement. Then came the most sensitive section, authorship and origin of supporting financial structure. The business plan style estate draft, used in early estate structuring discussions, contained annotations and revisions that matched handwriting and email metadata tied to her archived communications. The clerk confirmed timestamps. He confirmed origin points. He confirmed sequence. She was not being added back into the story. She was being restored to the record. The room did not react loudly. It reacted internally. That is what happens when proof is too precise to argue against immediately. people stop speaking because they are recalculating what they thought they already understood. The white billionaire mentor finally spoke, not as authority, but as observation. "Money gets loud when people lie," he said quietly. "Proof gets quiet when it is true." No one responded. Because there was nothing to respond to. The clerk then summarized the reconciliation outcome in formal terms. The archived ledger and original estate filing supported the inclusion of the younger woman in the initial estate structure, and the omission in the current probate file was not supported by documented procedural justification within the record history. That was the moment everything shifted. Not emotionally. Legally. Because in probate court, once the record history contradicts the current filing without explanation, the court cannot proceed as if nothing happened. The judge, who had remained silent through most of the proceedings, finally leaned forward and asked for confirmation whether the discrepancy required formal suspension of distribution until corrected filing history could be validated. The clerk answered simply, "Yes." And that single word changed the entire trajectory of the estate. No one celebrated. No one argued further. Because now the situation was no longer about interpretation. It was about correction. The heirs who had been confident moments earlier now sat in a different kind of silence, the kind that comes when a system stops moving forward until every past assumption is accounted for. The younger woman remained still, not because she had won anything yet, but because she understood what had just happened. The system had acknowledged that the truth existed in the records, not in the room. The billionaire mentor looked toward the sealed estate file one last time. Because what comes next in situations like this is never emotional resolution. It is procedural consequence. And as the judge requested formal pause on estate execution pending full reconciliation report, one reality became unavoidable for everyone present: the case was no longer about what people believed was true. It was about what the records would legally allow to remain true going forward, and who would be affected once the corrected estate structure was officially enforced. The probate court did not move forward immediately after the reconciliation report. Instead, it entered a controlled administrative phase where every corrected document had to be validated in sequence. No dramatic announcements were made, no sudden rulings were shouted, just procedural steps that slowly rebuilt the estate file into what it should have been according to the historical record. The lawyer representing the estate was the first to formally acknowledge the clerk's findings. In calm, measured language, he confirmed that the archived documentation and reconciled ledger required amendments to the current probate filing. This was not framed as accusation. It was framed as correction. In American estate law, that distinction matters more than anything else. The judge reviewed the updated comparison sheet line by line. He did not react emotionally. He did not speculate. He simply confirmed whether the discrepancies met the legal threshold for adjustment of estate distribution eligibility. And once he reached the section concerning beneficiary listing alignment between original intent records and current filing, he paused slightly longer than before. Then he nodded. That single gesture initiated the legal transition. The probate process was formally paused from execution and redirected into corrected validation status. This meant no distribution could be finalized until the amended filing was fully reviewed and signed into record. For the family members who had been confident earlier, the meaning of this was immediate and unavoidable. Nothing was being taken away. Nothing was being punished. But nothing could proceed under assumptions anymore. The estate deed references were rechecked against the corrected file. The clerk confirmed that ownership-linked documentation referenced in the archived version must be reinstated into the estate structure for proper legal alignment. That alone shifted multiple downstream assumptions about control and eligibility. Tax and payment histories were then reviewed again under the corrected structure. What mattered here was not just who was listed, but who maintained financial continuity during the period the estate assets were active but not fully transferred. Bank records confirmed consistency of responsibility that had not been reflected in the revised version of the file. As each section was corrected, the estate stopped being a narrative and returned to being what it always was supposed to be: a sequence of verifiable obligations, signatures, and recorded accountability. The younger white American woman did not speak much during this phase. She did not need to. Her presence was tied directly to documentation now officially reinstated into the estate record. The quiet billionaire mentor observed this carefully, not as someone emotionally invested, but as someone who understood how fragile confidence becomes when it is built on incomplete paperwork instead of complete history. At one point, the attorney addressing the court summarized the situation in a way that clarified the practical outcome without dramatizing it. The estate would remain under probate supervision until corrected filings were fully executed. Any previous assumptions regarding distribution hierarchy would no longer apply until final legal confirmation was complete. In other words, authority now followed documentation, not expectation. Outside the courtroom, as the legal team prepared the revised filings, a quieter reality began to settle in for everyone involved. This is where most financial and estate disputes reveal their true lesson, not in the correction itself, but in what caused the correction to become necessary. And that lesson was simple, but uncomfortable: keep records when things are calm, not only when they become disputed. Read contracts fully before they are signed, not after they are challenged. Know whose name is on the title long before anyone questions ownership. Track cash flow because emotion does not survive legal review. Protect signatures because signatures are what courts recognize, not intentions. And never confuse approval from people with security in law. Because in the end, systems do not run on feelings. They run on documented proof. As the revised estate file was prepared for final resubmission, the judge's office issued one final procedural instruction: the corrected estate structure would be reviewed in full before any further distribution steps could resume. No one celebrated. No one protested. Because at that stage, the only thing left was alignment with record truth. And as the courtroom slowly cleared, the question that lingered was not about who had spoken the loudest, or who had seemed the most confident. It was about something far more permanent: when the documents finally speak without interference, who will still stand where their name is actually recorded, and who will realize they were never legally there in the first place. By the time the corrected estate structure was fully accepted into the probate system, the case no longer felt like a confrontation between people. It felt like a correction of alignment between what was assumed and what was actually documented. The final hearing was brief. Almost understated. The judge confirmed that the amended estate file had been validated through proper reconciliation procedures. The clerk confirmed that beneficiary listings, financial responsibility records, and ownership-linked references now matched the archived source material. The attorney representing the estate acknowledged that the corrected structure would replace the previously incomplete version moving forward. There was no dramatic closing statement. No emotional resolution. Just procedural finality. And that is often how financial truth settles, not loudly, but irreversibly. The younger white American woman stood quietly as the final confirmation was recorded. There was no sense of victory in her expression, because what she had been protecting was never emotion, it was documentation. And documentation does not celebrate. It simply stands. The quiet white billionaire mentor remained seated until the very end. When he finally spoke, it was not to interpret the outcome, but to summarize the principle behind it. He said, almost casually, "People think power is something you show. In reality, power is something you structure before anyone challenges you." That sentence landed without resistance because it matched everything the court had just demonstrated. Ownership was not decided by confidence. It was confirmed by records. Cash flow was not implied by lifestyle. It was proven by continuity. Signatures mattered more than assumptions. Contracts mattered more than reputations. And timing, calm, documented timing, mattered more than emotional urgency. The woman did not look changed in a visible way, but something had shifted in how she understood the world around her. Not because she had won a conflict, but because she had seen how easily people confuse visibility with legitimacy. She had been underestimated because she was quiet. She had been dismissed because she did not perform authority. She had been questioned because she did not present herself as powerful in the way others expected. But none of that mattered when the records were finally aligned. The mentor did not give her advice in the traditional sense. Instead, he framed what had happened in a way that would stay with her beyond the courtroom. He said, family pressure will always try to rush your decisions. Business betrayal will always try to redefine your role. Social shame will always try to make you sign away clarity for comfort. But none of those things hold weight against properly maintained records. That is the part most people misunderstand about financial disputes. They think the battle is about convincing others. It is not. It is about having documentation that does not need persuasion. Because when systems are built correctly, truth does not need to argue. It only needs to be read. The estate case closed in procedural silence, but the lesson extended far beyond that room. People who understand money do not need to perform power. They build quiet systems that protect them when performance fails. They rely on ownership records, cash flow, history, properly structured contracts, verified signatures, consistent documentation, disciplined financial habits, and the calm patience to let truth surface at the right time instead of forcing it prematurely. And the younger woman understood something fundamental as she stepped out of the courthouse: the world does not ultimately reward who looks most confident in the moment. It protects who can prove what they stand on when confidence is no longer enough. The mentor walked beside her without urgency, without ceremony. Just presence. Because in his experience, clarity does not need reinforcement. It only needs recognition. And as they reached the exit, the final lesson of everything that had happened settled into something simple, almost quiet enough to miss, but impossible to forget. Do not spend your life trying to look powerful. Build a life where the truth, the records, and the assets can protect you when the room turns against you.